Okay, America, I think I've seen enough of the Purge law and Chicago's ending, creating a purge starting September 1st. It's going to be crazy. Where's all these memes coming from? Why is all these people saying there's a purge law, all these YouTubers and videos? Well, in actuality, it is just another attack on bail. Anytime we have systematic reform or systemic changes, this is what happens. The mayor, the governor, everybody from Chicago and Illinois sort of came out to state this, and even there's a repeal legislation happening. But why is everybody talking about this purge? What is the purge in concept to the law? Let's take a look into that, and I'm glad that we have some experts on hand to at least explain it and give us a better description of what is really happening.
Well, let's just set the record straight with everybody. The Safety Act is designed to keep murderers and domestic abusers, violent criminals in jail.
Governor J.B. Pritzker addressing rumors that Illinois' new Safety Act will be the onslaught of a real-life so-called purge. The law will make Illinois the first state to eliminate cash bail, allowing some alleged criminals to be released on a promise to appear in court.
Governor Pritzker says the goal is to address the economic disparities of the criminal justice system.
Making sure that we're, also addressing the problem of a single mother who shoplifted diapers for her baby, who is put in jail and kept there for 6 months because she doesn't have a couple of $100s to pay for bail. So that's what the Safety Act is about. Are there changes, adjustments that need to be made? Of course, and there have been adjustments made, and there will continue to be. Laws are not immutable.
The Safety Act will take effect January 1st. The new law says when a suspect is accused, the court will hold a hearing, may keep them behind bars if they are charged with a forcible felony, and that includes second-degree murder.
All right.
Justice system. Questions regarding the Safety Act stir debate across the state line. The county board even going as far as passing a resolution to repeal the act. 23 News reporter Anthony Ferretti speaks with area lawmakers and law enforcement about how it could change the criminal justice system as we know it.
It's incredible the list of charges that now will be released.
Boone County Sheriff Dave Ernest is one of several sheriffs in the area who sound the alarm about Illinois' plan to end cash bail January 1st. The Safety Act will allow some alleged criminals to be released from jail on a promise to appear in court.
One of the most frustrating parts is when we let somebody out with no bond and they don't show up for court, we don't go and arrest them.
This means 60% of inmates in Winnebago and Boone County jails will be eligible for release, but it doesn't mean that will happen automatically. Prosecutors can still argue someone should remain in jail if they're a danger to public safety, a flight risk, or a repeat offender.
There's people in jail because they simply can't pay, even though they're still considered innocent until proven guilty. We're just making this fair.
Democrats say the goal of the Safety Act is addressing the economic disparities of the criminal justice system. State Representative Maurice West says in the current system, the amount of money someone has determines whether they can be released, not if they pose a threat to people or are trying to get out of prosecution.
Who is able to file that petition? Our state's attorney. So I'm looking forward to him doing his job to ensure that those who are supposed to stay in jail, stay in jail.
But others argue the Safety Act will make crime in Illinois worse. That's why the Boone County Board works to repeal this law.
If you commit violence against somebody, and this is something now that you can just simply be released later in the day, this is not creating safe neighborhoods. Even the governor just recently has announced that there was problems with it and still remain problems, but we haven't seen a commitment to actually fix it.
2 county state's attorneys in Illinois are suing over the so-called Safety Act. This act, which Governor Pritzker signed last year, eliminates cash bail in Illinois starting on January 1st. The state's attorneys for Kankakee and Will counties today, both filing lawsuits alleging that the act violated the state constitution by not allowing voters to weigh in on it.
The purge is a time where they say this is a free-for-all. All crime is legal for the next 24 hours. That's the concept of the purge, right? That is not the case here in any way, shape, or form. What this law actually does, this is just redressing bail. You are not being given and invited for any free-for-all for crime. If they say you're dangerous, you're accused of these felonies, if you're accused of a violent crime, you're just going to be detained. My name is Olayemi Olurin. You can call me Olay. I am a public defender for the Legal Aid Society in New York. I am a political commentator and what I would just generally like to call a professional loudmouth. Our cash bail system, the way it works is people set bail on you, the court set bail on you, and if you have the money, you get out, you can buy your freedom, and if you don't, you sit in. And it really doesn't have a public safety component. It's often talked about that in the media. People, the minute you talk about cash bail, they go, oh, you want danger, crime. It has nothing to do with that. The actual legal reason why we have bail is to ensure that someone returns to court. That's the actual legal standard. When you go in court, it's not about whether or not this person is a safety risk. It's about whether or not you think they'll return to court. And our cash bail system weaponizes poverty as like, oh, you're poor, so we got to keep you in. And so then what happens is anybody poor just sits in jail pre-trial for years and years at a time. So that cash bail system, by eliminating that, what this does is it doesn't mean that anybody is out or free for all, which, not for nothing, I want to say this. People being out there, statistics actually do not support this idea that our media perpetuates, that crime is being committed by people who are out on bail. That's just not the case. But even if you did, whether or not you're on bail, whether or not detained, not detained, if you're out and you violate a term of your release, you will be sent back. So this idea that like, oh, by having people out, they're going to commit all this crime and that goes unchecked. But that's just categorically untrue. But what the new system will do, the Pretrial Fairness Act, when it comes into place in January 2023, it actually does have a public safety component in it that didn't exist before. Because now what happens is misdemeanors and low-level arrests, okay, you can't detain on this. But felonies, and most felonies are anywhere where it's violent crime, or the prosecutor could allege or articulate any grounds that you are a public safety, you actually pose a danger to public safety, you will just be detained. So in a world where you did pose a threat to public safety, but with cash bail, you have the money, you're out, regardless of how much you might endanger the public. But in this new rule, in this new system, the prosecutors and the judges do actually get to take into consideration public safety stuff and also add credence to our presumption of innocence, because now, instead of a mere accusation, the prosecutor actually has to articulate something, some actual grounds or evidence for why they want to detain you. The purge is a time where they say, this is a free-for-all. All crime is legal for the next 24 hours. That's the concept of the purge, right? That is not the case here in any way, shape, or form. What this law actually does, this is just redressing bail. That's all this is addressing bail. You are not being given and invited for any free-for-all for crime. Police can and will arrest everybody and their mama. But all this means is that, all right, so you commit crime. Instead of us saying, oh, we're going to put, this amount of money and you can leave, you can get out of jail whether or not you pose a danger to us or not. And if you don't have the money, you'll go in even though you don't pose a danger to us. What this says is, if you are committing crime or dangerous crime and you pose a safety risk to the public, you have violated a term of release before, or there's evidence to show that you will be a flight from prosecution, you will just be detained. A matter of factly, the court and the prosecutor, the judge and the prosecutor have the discretion to have you detained pre-trial altogether. But if you're accused of a misdemeanor or low-level or non-violent offense and there is no evidence, the prosecutor is not able to articulate a ground for why you pose a safety risk, they cannot keep you in jail pre-trial simply because you don't have the money. So it eliminates that aspect and actually adds credence to our presumption of innocence by requiring the prosecutor to actually have to allege some facts against you rather than there's an accusation and now I'm in jail. You want to live in a civil society where you have the presumption of innocence. There's a reason why America touts that so much. This idea that you can't just be accused of something and be thrown away. But advocating for a bail system where these people have only been accused of crimes. Evidence has not been presented. That's not what happens at arraignments. You can make an accusation. If right now I say you called me 15 times, cursing me out, you will be arrested for aggravated harassment in the 3rd degree in New York City. And it doesn't matter that I don't have to show up at arraignments. I don't have to show them any proof that you threatened me. I don't have to show them any call. All you need to do is make a mere accusation. So it actually does a lot more for adding legitimacy to a criminal system that so many people, insist that we should maintain our faith in and give an effort at reform. These incredibly just completely erroneous infographics that have been flying around. So, and people are reading that and thinking, oh, these people can't be, that's not what that means. What it means overall is we no longer will have a cash bail system, right? Just period, no cash bail system. It's not that, oh, these people accused of these crimes, oh, now they can't be detained because no cash bail. That's not what that means. If they say you're dangerous, you're accused of these felonies, if you're accused of a violent crime, you're just going to be detained. If they can articulate any kind of public safety danger against you of those felonies, now you're just detained pre-trial regardless of whether or not you could come up with any money. So it doesn't mean people accused of murder, any violent crime, most of these felonies, it in no way means now you're free. No, actually it means you are detained. The only difference is your freedom isn't based on a dollar amount. It's your freedom isn't determined based on your poverty. I love that they keep making this out to be this super radical effort, but places like New Jersey passed this equivalent in 2014 under Republican Governor Christie. They already eliminated cash bail. And how this actually works in application is just merely that most of these misdemeanors and traffic infractions and things that would never have been resolved with criminal cases, because I think that's the thing people don't realize so much about the system is most things would not be resolved in a criminal conviction. What happens is most things wouldn't even be punishable by jail time. But because of the bail system, people who otherwise would not have been sentenced to jail, they wouldn't go to jail. There wouldn't be a way to impose that on them and prove it to them. Now they go to jail. So now what we do now is how it will be done under this new law is traffic infractions, misdemeanors, low-level, non-violent crimes. They can't detain you unfairly. But everything else, you're gonna be detained. Listen to me. It cannot be understated how significant of a role the media plays in quashing progressive movements and keeping more Black people in jail. It's frustrating because every time we say the criminal system isn't broken, it's working as intended, these are the outlets and instances that respond, no, we still need to have faith in the system. We need reform, we need reform, we need reform. But then every time we actually get substantive progressive reform, here they go with campaigns like this filled with lies. And please trust that it's not a coincidence that they're going to places like the Shade Room and Baller Alert with Black audiences to peddle these lies, because what they want is for Black people to internalize propaganda and lies so that we don't support progressive initiatives that are designed to keep us out of jail. So I'm going to dispel these myths about the Purge law, because there is no Purge law. All there is a concerted effort by media, right-wing Republicans, and neoliberals to keep Black people in jail. You've probably heard about Rikers, because Rikers is infamous. But less people realize that Rikers is a pre-trial detention center, meaning the people incarcerated at Rikers have not been convicted of a crime. Last year, 16 people died in Rikers. This year, 13 people died in Rikers, and Rikers has already been declared a human rights crisis. So what if I told you that the crisis happening at Cook County Jail was worse? Cook County Jail is the pre-trial detention center in Chicago, Illinois, meaning the people incarcerated at Cook County Jail have not been convicted of a crime. They simply just don't have the money for bail. And that's an important point people need to understand about bail. Bail is not about public safety. Bail is about whether or not you can afford your freedom, period. I am a public defender who represents people that are incarcerated at Rikers, where people are killed, people are beaten, people are sexually assaulted, people spend years of their life. And I'm telling you that I was floored to find out that there are people sitting in Cook County Jail waiting on a trial for 4 years, 8 years, even 11 years. So let me tell you about what the Chicago Public Safety Act would do. The first lie being circulated is that this bail reform will prevent police from being able to make arrests. False. Not only can police arrest whoever they want, like they've always been able to, all the bail reform law does is encourage them not to make completely low-level arrests that they could write tickets for. And you wanna know what else? You wanna know what else? A law enforcement agency proposed that language. What the Public Safety Act would take low-level crimes, low-level misdemeanors, non-violent crimes, and instead of those being bail eligible, where you sit in jail because you don't have the money, you fight your case from the outside, because now judges cannot set bail and keep you incarcerated for something they probably otherwise would not have been able to. What this Public Safety Act would do is it would get rid of the cash bail system. It doesn't mean that nobody goes to jail pre-trial. It means that instead of whether or not you're free or you're in jail being determined based on how much money you have, instead, prosecutors would have 3 different options that they could keep you detained should they so choose. Prosecutors will have an option to present evidence to the judge showing that you are a threat to public safety, or that you have engaged in some kind of willful flight from prosecution, or if you're simply charged with most felonies and they can have you detained pre-trial. The reality is that the vast majority of people in our criminal system are living well beneath the poverty line. They're represented by public defenders because they cannot afford representation, which is a fact. The court, the same court that will then place high bail on them, they know they can't afford it. So it's a tactic by which we put poor people in jail for things we probably couldn't prove at a trial. They'll probably never have a trial. It's a way to coerce them into plea deals. But it is not about public safety, because at the end of the day, if you have the money, you can buy your freedom. So what this act does is it gets rid of that component, and it actually makes it about dangerousness. It makes it about whether or not the prosecutor has some evidence that he can present to justify detaining you pretrial, rather than just using and exercising your own wealth or lack thereof against you. Listen to me. Do not fall for the propaganda. They're calling it the Purge law because they want you to believe that a law designed at affording you more rights, at preventing you from being railroaded, at preventing more deaths from mounting inside a Cook County jail is not there to help you. It's a lie. This has nothing to do with public safety. Listen, we allegedly live in a civil society with a presumption of innocence where people should not die awaiting their trial for crimes they have not been convicted of. That shouldn't be what's happening, but that is what's happening each and every day inside this country at pretrial detention centers all around this country. But Cook County Jail and the pretrial detention centers in Chicago and in Illinois are some of the worst. This law is meant to help us. Do not mind the propaganda.